The courtroom fell silent when Officer Daniel Graves pointed at the elegant black woman seated across the aisle and declared, with the full confidence of a man who had never once been wrong in his own mind, "That's the woman who forged evidence and stole federal files." Jurors gasped. The judge's eyebrows dropped into a hard, unreadable line. The bailiff stepped instinctively closer to the gallery rail, one hand drifting toward his belt. Every head in the room swiveled toward the woman at the center of the accusation, and what they saw, what everyone in that courtroom saw, was someone who did not flinch, did not blink, and did not open her mouth to protest. She simply reached into her briefcase. Daniel smirked, certain she had just made the worst mistake of her life, that whatever she pulled out would prove nothing except that she had overextended herself. Instead, she calmly placed a dark blue leather credential case on the counsel table, pressed it flat with 2 fingers, and let it sit there beneath the courtroom lights. 3 letters gleamed on the surface: F, B, E. Then she looked directly into Daniel Graves's eyes and said, in a voice that was steady as granite and just as cold, "Officer Graves, thank you for committing obstruction of justice on the record. We've been building this case against you for 18 months. Her name was Naomi Carter, and she had been in rooms like this one before. Not always dressed the same way. Sometimes she wore field gear, sometimes a windbreaker, sometimes nothing more official looking than a blazer over dark jeans. But the feeling was always the same. The particular electricity of a space in which the truth had not yet fully arrived, and everyone was still pretending otherwise. She was 38 years old, with close-cropped natural hair, and the kind of stillness that people often mistook for passivity. She wore a charcoal blazer over a white blouse, small pearl earrings, and a watch that had been her mother's. She carried a worn leather briefcase that held, among other things, 18 months of work product, 412 pages of documented evidence, 17 hours of recorded audio, and a credential that she had not needed to show anyone in this room until this moment. She had sat down in the 3rd row of the gallery that morning without introducing herself to anyone. She had accepted a paper cup of coffee from a clerk who offered it without any idea who she was. She had reviewed her notes in silence, nodded once to a colleague she spotted near the door, and then settled in to watch Officer Daniel Graves walk into the room, believing he owned it. She had spent the better part of an hour, the previous evening, reviewing her notes one final time, not because she needed to, but because she was the kind of person who did not trust certainty that hadn't been recently verified. Every name, every date, every account number had been cross-referenced against the source documents. The case was as solid as 18 months of careful work could make it. She had closed the folder, set it on her hotel nightstand, and slept 6 hours without dreaming. Daniel Graves was the kind of man who filled a doorframe on purpose. He was broad-shouldered, with a jaw like a shelf, and the practiced bearing of someone who had learned early in life that physical presence was a form of argument. He had been on the force for 14 years. He had more commendations than any other officer in his precinct, a fact he mentioned with the frequency of a man who believed that repetition was the same as truth. His name had appeared in the newspaper 11 times in the past 3 years, twice for Valor Awards, once for a charity run he'd organized, and 8 times in connection with use-of-force complaints that had each been reviewed, investigated by colleagues, and quietly closed. He walked into the hearing room that morning, with 3 union representatives at his back, his dress uniform pressed to a crease so sharp it looked like it could cut paper, and the comfortable expression of a man who had been in these rooms before and had always walked out the same way he walked in, untouched. He greeted several people in the room by first name. He accepted a handshake from one of the oversight board members with the easy warmth of someone doing the board member a small favor by acknowledging him. He spotted Naomi almost immediately. She was seated in the 3rd row, not at the council table, not in uniform, not carrying any visible badge of official status. She was simply a black woman in a blazer, with a briefcase on her lap, and when his gaze passed over her, something shifted almost imperceptibly in his expression, not alarm, not recognition, just a flicker of mild, reflexive disdain, the kind that arrives without conscious instruction. He looked away. He took his seat. He leaned over and murmured something to one of the union reps that made the man beside him smile. The hearing was convened to examine a use-of-force incident from the previous spring, a confrontation in which a 22-year-old man named Marcus Webb had been restrained, injured, and subsequently charged with resisting arrest. Webb's attorney had filed a formal complaint. A community oversight board had requested the proceeding. The department's position, argued by Daniel and supported by 3 other officers who had been present that night, was simple. Everything had been by the book. The young man had been combative. The force used had been proportionate. The paperwork had been filed correctly and on time. There was nothing to see here, nothing to examine, and the whole proceeding was. In Daniel's words, spoken loudly enough in the hallway before the session began for several people to hear, a performance for people who don't understand how policing works. Naomi had been standing 8 feet away when he said it. She had written the phrase down in her notebook, word for word, with the time and the names of the 3 witnesses who had heard it alongside her. She did not look up. She did not react. She finished writing and turned the page. When the hearing officer called for questions from the floor, Naomi rose from her seat in the 3rd row and approached the front of the room without any introduction, without any preamble, and without the faintly apologetic energy that people often expected from someone who looked like her in a room like this. She placed her briefcase on the edge of the counsel table, opened it, and withdrew a legal pad. Daniel watched her cross the room with the studied indifference of a man performing boredom for an audience. And when she finally stopped and looked at him, he offered her the most dismissive thing in his arsenal, a slow, patient smile, the kind you give someone who is about to waste your time. "Can I help you?" he said, before she had spoken a single word. The hearing officer reminded him that the floor was open for questions. Daniel spread his hands in a gesture of magnanimous tolerance. Naomi did not acknowledge any of this. She simply looked down at her legal pad, looked back up at him, and said, "Officer Graves, I have a few questions about the events of the evening in question. I'd appreciate straightforward answers." He said, "I'll do my best," in a tone that meant the opposite. She said, "I'm sure you will," in a tone that meant she already knew exactly how this was going to go. The first thing Daniel did was call her the wrong name. Not dramatically. Not obviously, just a small, sliding mispronunciation, dropping a syllable from Naomi so that it came out slightly wrong, slightly less, the way some people do when they want to remind you that your name is foreign to them and they consider that your problem. She did not correct him. She wrote something on her legal pad. He did it again 5 minutes later, this time more deliberately, watching her face for a reaction. She gave him none. She wrote something else on her legal pad. By the 3rd time, a woman seated in the 2nd row had noticed and begun to frown. By the 4th time, even one of the union representatives had shifted slightly in his seat. Naomi Carter simply kept writing, and each time Daniel mispronounced her name, she recorded it, with the time, in her notes, not because she needed it, not because it constituted evidence of anything criminal, but because she was the kind of person who documented everything, the kind of person who had learned long ago that the details that seem too small to matter are often the ones that matter most. It did not take long for Daniel to stop performing patience and begin performing contempt. He had a gift for it, a way of pivoting from surface-level courtesy to open condescension that was smooth enough to be deniable and sharp enough to land. When Naomi asked her first substantive question about the timeline of events on the night of the incident, he answered it with an explanation that was about 40% longer than necessary, delivered in the slow, careful cadence of someone explaining a complex concept to a child. "I understand this might be complicated," he said at one point, and left just enough of a pause afterward for the implication to hang in the air. Naomi wrote it down. When she pressed for a specific time, not a range, not an approximation, but a specific time, he sighed audibly and said, "I don't have the exact minute memorized. Some of us have more important things to think about during an active incident than watching the clock." A few people in the gallery chuckled. One of the officers, seated along the right wall, smiled. Naomi did not look up from her legal pad. She said, "Of course. Let's move on," and moved on, and Daniel, reading her continued calm as confirmation that he had won that exchange, relaxed slightly into his chair, and allowed himself to feel the proceeding slipping back into familiar territory. "Don't turn this into a racial performance," he said, when she asked about the department's documented patterns of use of force in certain neighborhoods, a question she had posed plainly, without heat, without accusation, citing 3 specific departmental reports by title and publication date. The room stirred. A few of the officers along the wall made sounds that were not quite laughter, but were meant to function as social permission for laughter. The hearing officer looked uncomfortable. One of the community board members shifted in her seat, with the expression of someone deciding whether to speak. Daniel looked at Naomi with the air of a man who had just said the quiet part loud and was entirely untroubled by it. Naomi looked back at him. She wrote something on her legal pad. Then she said, in exactly the same tone she had been using throughout, "I'm citing published departmental data. My question stands." He answered it. He gave her a non-answer wrapped in confident language, which was his preferred technique. But he answered it, and she wrote down the answer, and then she turned the page on her legal pad and moved to the next question. What Daniel could not know, what no one in that room yet understood, was that each non-answer was itself data. Each evasion had a shape. Each careful silence pointed at something, the way shadows point toward light. She was not trying to break him with her questions. She was giving him precisely enough rope, and he was taking it with both hands. He said, near the end of his first long answer, "I have never done anything wrong in my career. Not once." He said it the way people say things they believe will become true if said with enough conviction. He said it looking at the hearing officer, at the board members, at the room, not at Naomi, because she had become, in his mental map of the proceeding, a minor obstacle he had already cleared. He was wrong about that. He had never been more wrong about anything in his life, though he would not understand this for another 23 minutes. The questions that followed were quiet. They were specific. They were asked without raised voice or visible emotion, and they did not feel like accusations. They felt more like a surveyor's measurements, each one placed with deliberate precision at a particular coordinate, mapping something that had not yet become visible to the room. Naomi asked about the location of camera unit 7 on the night of the incident. She asked it the way you ask about something you already know the answer to, which is not the way people typically ask questions in rooms like this one, and it caught Daniel slightly off balance. He said the camera had malfunctioned. She asked when the malfunction had been reported. He said he didn't recall the exact timing. She noted, without inflection, that the malfunction report had been filed 3 hours after the incident concluded, not before, and asked if he could explain the discrepancy. He said he was sure there was a simple explanation. She said she was sure there was too, and moved on. She asked about camera unit 4. She asked about the shift log for the monitoring station. She asked whether anyone had reviewed the backup storage for that night before the malfunction report was filed. Each question landed in the exact place the previous one had opened up, and the structure she was building was becoming, to anyone paying close enough attention, impossible to miss though Daniel Graves was not, at this point, paying close enough attention. She asked about the incident report. Not the content of it, the metadata, the timestamp on the original file, the timestamp on the version that had been submitted, the name of the officer who had accessed the document between those 2 timestamps. Daniel answered the first 2 questions with the ease of a man who did not yet understand what was being assembled around him. On the 3rd question, he paused. It was only a brief pause, 2, maybe 3 seconds, but in a room this quiet, pauses of that length are noticeable. He said he believed it had been a routine administrative review. She asked if routine administrative reviews typically changed the content of incident reports. He said he wouldn't characterize any changes as significant. She asked what changes had been made. He said he didn't have the document in front of him. She said she did, and she set it on the table and slid it 2 inches toward him without looking up from her legal pad. The sound it made on the table was very small. Several people in the gallery leaned forward. A public defender seated near the back wall set down his pen. A prosecutor from the district attorney's office, who had come purely as an observer, who had expected nothing from this morning, except the usual procedural choreography, sat up slightly in his chair and began paying a prosecutor different quality of attention. Daniel looked at the document. Then he looked at Naomi. Then he looked at the document again. He said, "These changes are immaterial." She asked him to define immaterial in this context. He said, "This is a fishing expedition." She said, "I'm only asking about documents that have already been produced." The hearing officer reminded Daniel that he was required to answer. Daniel answered, and in answering and choosing the specific words he chose to answer with, in the specific framing he selected to make the changes sound small, he confirmed 3 things that Naomi had not yet been able to confirm through any other means. She wrote them down without expression. She turned another page on her legal pad. It was the nature of Daniel's particular kind of confidence that it read pressure as provocation rather than as warning. A more cautious person, a person with a more accurate map of their own situation, would have recognized by now that the questions were too specific, that the woman asking them knew too much, that the proceeding had shifted into something other than what it had appeared to be. Daniel did not recognize any of this. What he recognized was that he was being challenged, and what he always did when challenged was push back harder. He began to add detail to his answers. Unsolicited detail, elaborations that were meant to demonstrate how fully and firmly he stood behind his account. He mentioned the name of a colleague who had been with him at a specific time. He placed himself at a specific location at a specific point in the evening. He confirmed a sequence of events in a way that locked in a timeline he had, until that moment, been careful to keep slightly vague. He did all of this because he believed it made him look confident. He did not know that each piece of additional information slotted into a structure that was already built and waiting for it the way the last few pieces of a puzzle suddenly make the picture unmistakable. He was constructing his own trap from the inside, one confident sentence at a time, and the woman across from him was simply letting him work. Naomi's colleague, near the back of the room, a man in his mid-40s, who had been sitting very still for the past 40 minutes, apparently reading something on his phone, looked up briefly when Daniel named the colleague. He made a small mark in a small notebook that no one around him would have noticed unless they were specifically watching for it. He was not from the district attorney's office. He was not from the oversight board. He was Special Agent Raymond Cho, and he and Naomi had been working the same investigation from different angles for the past year and a half, tracking separate threads that had gradually converged into a single, coherent picture of what the department's internal culture had permitted and protected. He put his phone in his pocket and settled back in his chair, and his expression, for just a moment, was the expression of a man watching the last piece fall into place. When Daniel finally lost his temper, it happened fast. Naomi had just asked calmly, precisely, in the same unvarying tone she had used for every question in the past 45 minutes, about a set of financial transactions involving a department discretionary fund. She had cited account numbers. She had cited dates. She had cited amounts. The specificity was impossible to explain away. It was the kind of specificity that you could only have if you had been inside the department's financial records for a very long time, and Daniel Graves knew, with sudden and complete certainty, that those records were not public. He stood up. He pointed at her. He said, "Where did you get those numbers?" And his voice had lost all of its earlier polish. It was raw now, stripped down to the anger underneath. He said she had no right to those documents. He said those were classified records. He said, his voice rising, "I don't know who you are or where you came from, but you have forged evidence. You have stolen federal files, and I'm going to have you removed from these proceedings and charged." The room erupted briefly, not in agreement, not in applause, just in the kind of noise that happens when a space is suddenly electrified with tension. The hearing officer called for order. The bailiff moved closer. Several people reached for their phones. Naomi stood up. She was not hurrying. She opened her briefcase. She withdrew the dark blue leather credential case, set it on the counsel table, pressed it flat with 2 fingers, and let it sit there. Then she looked at Daniel Graves, who had gone very still, the way people go still when the floor has just shifted under them, and she said, clearly, with no elevation in her voice whatsoever, "Special Agent Naomi Carter, Federal Bureau of Investigation." She paused for exactly 1 beat. You just publicly accused a federal agent of evidence tampering and theft in an active federal proceeding. That's obstruction of justice, Officer Graves. I want you to know that everything you've said in this room today is on the record." Daniel looked at the credential. He looked at her face. He looked at the credential again. His mouth opened slightly. Nothing came out. The union representative to his left had leaned forward and was staring at the badge on the table with the fixed expression of a man whose worst morning just became considerably worse. Somewhere in the gallery, a woman said quietly, "Oh my God." Someone else exhaled audibly. The hearing officer called for order a second time, and this time the room obeyed, because the room understood, even if it could not yet articulate exactly what it understood, that something had just fundamentally changed. The room did not reassemble itself quickly. These kinds of moments, the ones where a proceeding suddenly reveals itself to be something entirely different from what it appeared, leave a particular kind of stunned silence in their wake, the silence of a room full of people simultaneously revising their understanding of the past hour. Naomi did not rush to fill it. She waited, credential on the table, legal pad in her hand, for the hearing officer to restore order. When he did, she continued. What she laid out over the following 30 minutes was not a dramatic presentation. It was not theatrical. There were no raised voices, no rhetorical flourishes, no appeals to emotion. She spoke the way you speak when you have so much evidence that you no longer need to perform conviction. You simply present facts, one after another, and let their accumulated weight do the work. She said that the FBI's Public Corruption Unit had opened an investigation into Daniel Graves and several of his colleagues 18 months prior, following a referral from the Department of Justice Inspector General's office. She said the investigation had documented a pattern of conduct that included the manipulation of incident reports, the systematic disabling of recording equipment during certain types of encounters, the use of department resources to intimidate witnesses, and the falsification of arrest records in connection with at least 14 separate cases. She said that Daniel Graves was not an isolated case of a single officer with bad judgment. He was, according to the investigation's findings, the operational center of a network that had been functioning inside the department for at least 6 years. She said all of this in the same measured, documentary tone she had used to ask questions about camera malfunctions and report timestamps, and the room absorbed it the way a sponge absorbs water completely, immediately, visibly. She connected a laptop to the hearing room's display screen. The first image she showed was a surveillance photograph, not from a police camera, from an FBI camera taken outside a restaurant 14 months ago. It showed Daniel Graves at a table with 2 men, one of whom was a city contract officer with authority over evidence storage facilities. She showed an email thread. The emails were between 2 department accounts, and they discussed, in language that was almost comically direct, given its content, the procedure for altering timestamps on submitted reports. She showed a series of text messages extracted from a phone that had been obtained under a federal warrant 8 months prior. She showed a spreadsheet of financial transactions, the same account number she had cited in her questions, that documented a series of payments corresponding to no legitimate departmental expenditure. She showed a list. It contained 19 names. 11 of them were sworn officers in Daniel Graves's precinct. 3 were administrative staff. 2 were individuals outside the department entirely. The remaining 3 were people who had already been separately charged in related proceedings. The list stayed on the screen for a long time, long enough for everyone in the room to read it twice. The officers seated along the right wall of the hearing room had been, for the past 20 minutes, progressively less still. Some of them were now visibly pale. 2 had leaned together and were speaking in voices too low to hear. One was looking at the list on the screen with the expression of a man trying to locate his own name from across the room and hoping very much that he cannot find it. Daniel Graves was doing none of these things. Daniel Graves was looking at Naomi Carter with an expression that had moved through rage and shock, and something approaching disbelief, and had arrived, finally, at a place that was harder to name the expression of a man who has spent years in a room he believed was sealed, and has just discovered that someone has been watching through the walls the entire time. He tried, still. That was the thing about Daniel. He had survived so many rooms by sheer force of will, that he had come to believe the rooms were what changed, not the situation. He tried denial first, which failed immediately, and publicly, because the documents were on the screen, and the screen was visible to everyone. He tried procedural objection, argued that the evidence had been improperly obtained, that the hearing was not the appropriate venue, that the FBI had no jurisdiction over a departmental review, and the hearing officer reminded him, with visible impatience, that a federal agent had just made a formal presentation and that the question of jurisdiction was not one the hearing officer was authorized to resolve unilaterally. He tried, briefly, to blame a subordinate, suggesting that a younger officer in his unit had been responsible for certain irregularities without Daniel's knowledge, and Naomi, without looking up from her legal pad, placed a document on the table that contained an email from Daniel's own account authorizing the specific action he had just attributed to the subordinate. He looked at it. He stopped talking. For the first time in 14 years of navigating these rooms, Daniel Graves did not have a next move. The prosecutor from the district attorney's office, who had come to this proceeding as an observer and was now furiously filling pages of his notepad, stood and formally requested that the hearing be paused pending coordination with federal authorities. He cited specific statutes. He was precise, and he was fast, and it was clear that he had been reviewing his options for the past several minutes and was now acting on a decision he had already made. The hearing officer granted the request. Several members of the oversight board were on their phones. Raymond Cho, who had been quietly present in the back row for the entirety of the proceeding, now stood and moved toward the front of the room, where he produced his own credentials and began a brief, inaudible conversation with the hearing officer. 2 additional federal agents who had been stationed outside the building entered through the side door, moving with the calm efficiency of people executing a plan that had been thoroughly rehearsed. The audio recording was the last thing Naomi presented before the formal pause was called. She did not announce it dramatically. She simply said, "There is one more item I'd like to enter into the record before we adjourn," and she pressed play on a small device connected to the room's speaker system. The voice on the recording was unmistakably Daniel Graves. The recording had been made 13 months ago, in a break room in the precinct building, picked up by a device that had been legally placed under a federal warrant, Daniel's voice said, with the easy confidence of a man in a room he believed was entirely private. "Nobody's ever going to investigate us. We know where everything is. We control what gets reported and what doesn't. Nobody's coming." There was the sound of a second person laughing. Then the recording ended. For a moment, the room held the sound of nothing at all. No one moved. No one coughed. The display screen behind Naomi showed the list of 19 names, and the afternoon light came through the high windows at an angle that illuminated the dust motes turning slowly in the air, and then the hearing officer cleared his throat and called the recess. Daniel was arrested within the hour. Not dramatically, there was no scuffle, no resistance, though the union representatives spent several agitated minutes on their phones before the moment arrived, running through options that had already run out. He was placed in handcuffs by 2 federal officers while still inside the hearing room, in front of the gallery that had watched the entire morning's proceedings, in front of the board members and the attorneys and the clerks, and the prosecutor from the district attorney's office who was still writing. He did not say anything when the cuffs went on. He looked once more at Naomi Carter, who was closing her briefcase and organizing her documents with the careful, practiced efficiency of someone finishing a task they have completed many times before. He held her gaze for a moment. She did not look away. She did not say anything. She did not need to. The credential case was back in her briefcase. The legal pad was closed. The work, for today, was done. In the weeks that followed, the scope of what the investigation had uncovered became a matter of public record. 14 cases were immediately flagged for review cases in which convictions had been obtained, in whole or in part, on the basis of evidence that had been altered or testimony that had been coordinated in ways that contradicted the documented record. 3 of those 14 cases involved individuals who were currently incarcerated. Emergency review proceedings were opened. An outside oversight commission was brought in to assess the full extent of the damage, and their preliminary report, issued 6 weeks after Daniel's arrest, described what they found as a systematic and deliberate pattern of corruption, sustained over an extended period through the exploitation of institutional trust. 9 additional officers from Daniel's precinct were placed on administrative leave pending further investigation. 2 resigned before formal proceedings could be initiated. The city's police oversight board announced a comprehensive review of its own review procedures after it became apparent that several of the complaints that had been filed against Daniel Graves over the years had been routed through a departmental review process that was itself compromised, reviewed by people who either knew what was happening or had been sufficiently incentivized not to look too carefully. Marcus Webb, the 22-year-old whose case had been the formal subject of the morning's hearing, had his charges formally dropped 4 days after Daniel's arrest. He sat in a courtroom while a judge read the order, and he held his mother's hand the entire time. And when the judge finished, he sat very still for a moment with his eyes closed, and then he nodded once, slowly, the way people nod when they are accepting something they were not sure they would ever receive. His attorney released a short statement that said, in part, that his client hoped the investigation would bring clarity to all the families who had been through what his family had been through, and that clarity, even when it came late, was still worth having. Marcus Webb did not hold a press conference. He did not make any public statements beyond what his attorney said on his behalf. He went home, and he had dinner with his family, and he tried to remember what his life had felt like before the evening in question, and he found that the memory was there, but that it had changed shape in the time he'd been away from it. Grown quieter, more precious, and somewhat harder to reach. The reporter who caught Naomi on the courthouse steps as she was leaving did not know her name. He had gathered from the proceedings, from overheard conversations, from the credentials she had placed on the table, that she was the FBI agent at the center of the morning's events, but beyond that, he had nothing. He introduced himself and asked if she had a moment. She stopped. She considered him. She said, "One question." He said, "Does this feel like a victory?" She looked at him for a moment without answering, and then she looked down at the credential case in her hand, the dark blue leather one, worn at the edges from years of use, and then she looked back at him. She said, "What happened today was a result of 18 months of work by a team of people who kept going when it would have been easier not to. Victory isn't the right word. The right word is accountability, and accountability doesn't belong to anyone in particular. It belongs to the process." The reporter started to ask a follow-up. She said, "That was your one question," and she descended the courthouse steps into the afternoon light. She had a meeting at 3 o'clock, a coordination call with the Inspector General's office about 2 related investigations that were still in their early stages. She had notes to finalize, evidence logs to submit, a formal written account of the morning's proceedings to complete before the end of the business day. She was not, by any conventional definition, done. This was the nature of the work. It did not culminate in a single morning, no matter how significant that morning was. It accumulated. It built. It required the kind of patience that most people found genuinely uncomfortable. The patience to watch and wait and document and wait some more. To resist the pull of the dramatic moment and remain committed to the long, unglamorous architecture of proof. She had learned this early in her career, from a mentor who had told her, on her very first week in the field, that the most important thing she would ever do in this job was finish her paperwork accurately and on time, every time, without exception. She had thought, at 24, that this was a strange thing to tell someone starting their career. She understood it now with the clarity of someone who had spent 14 years watching the difference between what happened and what could be proven, and learning case by case, document by document, hour by patient hour, how to close that distance. The afternoon was warm. The courthouse steps were broad and white, and caught the sun at an angle that made everything look slightly more significant than it was, or perhaps, she thought, exactly as significant as it was. She passed a group of law students on their way in, young and serious, carrying identical canvas bags, probably here for a class observation or a moot court session. One of them recognized her, or thought he did, and said something to the person next to him, who craned to look. She did not slow down. She was already thinking about the 3 o'clock call, about the two related cases, about the evidence logs and the ongoing work, about the things that still needed to be done in the slow, patient, unglamorous way that justice actually gets done when it gets done at all. Not loudly, not theatrically, not with a single brilliant moment of confrontation, though those moments happened too and were real and mattered, but mostly with careful attention and the willingness to keep going long after the work had stopped feeling exciting, long into the part where it was simply necessary. She had been asked, once, early in the investigation, whether she was angry. It was a colleague who asked someone who had reviewed the initial case files and wanted to understand her emotional orientation toward the material. She had thought about the question seriously before answering, which was how she approached most things. She said, "No, not angry. Anger was a resource, and she had found better uses for it. What she felt," she said, "was something closer to obligation, the particular weight of knowing something that needed to be known by more people, and having both the tools and the authority to make that knowledge matter, in a way that could not be ignored or quietly closed." The colleague had nodded and written something down and never brought it up again, but she had continued to think about the answer in the months that followed, turning it over, checking it for accuracy, the way she checked her documents, and she had concluded that it was still true. She was not angry. She had never done this because she was angry. She had done it because it needed to be done, and she was in a position to do it, and she had been trained to understand that those two facts, taken together, constituted a responsibility that was not optional and not negotiable and not something you set down when the room got uncomfortable. Daniel Graves would be arraigned the following morning on 14 federal counts. The list included obstruction of justice, evidence tampering, perjury, witness intimidation, and conspiracy to deprive citizens of their constitutional rights. His attorney, reached by phone that evening, said his client maintained his innocence and intended to contest every charge. His 14 years of commendations, his 11 newspaper appearances, his department awards, the handshakes and the testimonial dinners, and the comfortable certainty of a man who had always walked out of these rooms exactly the way he walked in. None of it was relevant now to anything except the background narrative of how he had come to be standing where he was standing. The courtroom where his arraignment would take place was 12 blocks away from the hearing room, where Naomi Carter had placed a credential on a table and changed the trajectory of the morning. He would enter through a different door. He would stand in a different configuration. But the architecture of what had happened, the 18 months of documented work, the 412 pages of evidence, the 17 hours of audio, the patience, the absolute and unbroken patience of someone who understood that justice does not arrive on the schedule of the people who most need it, but that it can arrive if the work is done correctly and completely and without shortcuts. All of that would still be true. All of that would still hold. She reached her car. She set the briefcase in the passenger seat. She started the engine. She had 45 minutes before the 3 o'clock call, and there was a coffee shop 2 blocks from the field office where they made the kind of black coffee that tasted like it understood what it was for. She pulled out of the parking structure and into the afternoon, and the courthouse receded in her rearview mirror, white stone and wide steps, and the long shadow of something that had been done there today. Something real, something durable, something that had taken a long time to build, and that would continue to matter long after the morning was forgotten by the people who had only been present for an hour of it. She drove. She did not look back. The work that remained was already taking shape in her mind, clear and specific and waiting to be done, and she was, as she had always been, exactly where she was supposed to be. When power is abused, justice does not arrive as rage. It arrives as documentation. It arrives as patience. It arrives as a woman with a legal pad who has been in the room the whole time, writing things down, waiting for the moment when the record becomes undeniable. Justice does not need to announce itself. It does not need to perform. It only needs to be thorough. 18 months of thoroughness had just walked out of a courthouse in the afternoon sun, and somewhere behind her, in a room with high windows and rows of empty seats, a list of 19 names was still on a screen, waiting to be reckoned with. There was a moment, about 6 months into the investigation, when Naomi had almost nothing. Not literally nothing. She had threads, she had instincts, she had 3 witnesses who had come forward anonymously and whose accounts aligned in ways that were meaningful but not yet provable. She had a pattern that she could see but could not yet demonstrate. She had sat in the field office one evening, long after everyone else had gone home, and looked at the board on the wall, the photographs and the timelines and the connecting lines drawn in dry erase marker, and she had felt, for the first time in the case, the particular fatigue that comes not from working too hard, but from working in the absence of visible progress. She had sat with that feeling for a while. She had eaten half a sandwich that she had brought from home and forgotten about. She had looked at the board. Then she had taken out a fresh legal pad and started a new list, the things she still needed, in order of what they would tell her, and the most plausible path to each one. It was not dramatic. It was not inspiring. It was the kind of work that no one writes about, and that makes everything else possible. And she had done it. And she had gone home at midnight. And she had come back the next morning and started from the new list. That was 6 months before the hearing. The following 3 months had been the most productive of the investigation. The colleague who had asked whether she was angry had also asked, separately, and on a different occasion, whether she thought about the victims. This was a question she answered more quickly. Yes, always, but not in the way that most people meant when they asked it. She did not think about them as motivation, as faces to hold in her mind when the work was hard. She thought about them as people who existed in the real world, who had been affected by specific actions taken by specific people, and whose situations could potentially be remedied if the investigation produced something solid and true and usable. They were not abstractions. They were not inspiration. They were the reason that accuracy mattered, that every document needed to be exactly right, every timestamp verified, every chain of custody documented without gaps. An investigation built on emotion collapsed under cross-examination. An investigation built on verifiable fact did not. She had learned this from watching other people's cases fall apart, and she had made herself a promise early in her career that her cases would not fall apart that way. She had kept that promise through 14 years, and the particular kind of discipline it required, which was not the discipline of suppressing feeling, but the discipline of not letting feeling do the work that evidence needed to do. Marcus Webb had not known, until 4 days after Daniel's arrest, that the FBI had been investigating his case as part of a larger inquiry. He had not known that the woman he'd heard about, the agent who had confronted the officer in the hearing room, had, among the 412 pages of her documented evidence, a section specifically dedicated to the circumstances of his arrest and the alterations that had been made to the record afterward. He found out when his attorney told him, quietly, in a small conference room that smelled like coffee and old carpet. He had sat with this information for a moment. Then he asked his attorney if he could write a letter. The attorney said, "Of course." The letter went through the appropriate channels and eventually reached the field office, where it was logged, acknowledged with a formal reply, and kept on file. Naomi read it on the afternoon of the day it arrived. It was 4 paragraphs long, and it was precise, and it was not sentimental, which was the thing she found most striking about it, the way it described what had happened to him and what the investigation's outcome had meant to him, without reaching for easy language, without performing gratitude, in the way that people sometimes performed gratitude when they were writing to institutions. He said, in the second paragraph, that he had not expected the system to correct itself. He said this not as a criticism, but as an honest accounting of his prior experience. He said that it having done so, even partially and late, had changed something in how he thought about what was possible. She read it twice. She set it down. She went back to the case she was working on, which was different from his and from Daniel's, and she kept going. The field office held a brief internal review of the investigation 2 weeks after the arraignment, as it did with all major case closures. Naomi presented the summary, the timeline, the methodology, the evidence categories, the interagency coordination, the outcomes. She answered questions from senior agents about the decision to conduct the final confrontation at the departmental hearing rather than in a more controlled setting. She explained the reasoning. The hearing provided a venue in which Daniel Graves would be comfortable, in which he would behave as he had always behaved in rooms like that one, and in which his behavior and his statements would be officially on the record, in a way that a controlled interview would not have produced. The goal had not been to embarrass him. The goal had been to create a situation in which his own patterns of behavior would produce the final confirmation the case needed: the obstruction, committed in public, on the record, in front of witnesses. It had worked because he was exactly the person the investigation had assessed him to be. A man so confident in his own invulnerability that he could not recognize the walls closing in until they had already closed. The senior agents nodded. Someone asked if there had been any point at which the plan might have failed. She said yes, several, and described them with the same specificity with which she described everything else. Someone else asked what she would do differently. She thought about it for a moment, genuinely. Then she said, nothing about the investigation itself. She would sleep more during the last 2 months. The room laughed briefly, and she allowed herself a small smile, and the review continued. Raymond Cho submitted his portion of the final case summary the same week. He and Naomi had not worked in close proximity. For most of the investigation, they had been tracking different threads in different cities, coordinating through encrypted channels and occasional in-person briefings, but they had worked in the same direction, and the convergence of their separate findings into a single coherent evidentiary picture was, he wrote in his summary, the clearest demonstration he had encountered in his career of what disciplined parallel investigative work could produce. He included a note at the end of his summary that was slightly outside the standard format, which the reviewing agent flagged but did not remove. It said, the outcome of this investigation reflects the standard of work that should be expected and consistently delivered. It reflects it because it was built on that standard day after day without shortcuts. The reviewing agent added a margin note that said simply, agreed. The summary was filed. The case was closed. The related cases that had been opened in its wake would take years to fully resolve. The work went on. Naomi Carter drove to her next assignment 6 days after the arraignment. It was in a different city, a different kind of case, a different configuration of people and institutions, and patterns that needed to be mapped and documented, and eventually made provable. She packed the way she always packed, efficiently, with nothing left behind that she would need, and nothing brought that she wouldn't. The dark blue leather credential case went into her bag first, as always. The worn legal pad went in second. She locked her apartment, walked to her car in the early morning before the day had fully decided what it was going to be, and she drove. The highway was quiet. The sky ahead of her was the particular pale color it gets just before full daylight arrives. Provisional, uncommitted, full of the particular kind of potential that belongs to early morning and to the beginning of cases that are not yet what they will become. She drove toward it, and the city she was leaving receded behind her. And she was already thinking about the new case, and she was already, in the careful and methodical way that was entirely her own, already beginning.